And so are there any nominations for Vice Chair?
I'd like to nominate Councillor Monique Bonny.
I'll second that nomination. Councillor Bonny. Thank you, Chair.
Are there any other nominations? Is everyone in agreement that Councillor Bonny, when she arrives as Vice Chair, we'll let her know. I think that is still carried. Okay, so before we get on with the meeting, if any members or officers in physical attendance then an electronic device, please can you mute it? Otherwise, we're going to get feedback. And if any remote participants can keep their camera and microphone off unless they wish to speak, and ideally not to use a camera facility at all, as this can cause problems. The meeting may be recorded and data collected during the recording of the meeting will be retained according to the Council's data retention policy. The recording of the meeting may be added to the Council's website. Members accessing the meeting remotely should use their SBC or KCC laptops to participate. And if you join using the link, we may not recognise you and you may not be recorded as being in a remote attendance. So, welcome to the Planning and Transportation Policy Working Group, and particularly to any members visiting remotely and any members of the public. The following staff are in attendance in the Council Chamber. We have Interim Head of Planning Services, Joanne Johnson, Jill Peat, Planning Policy Manager, Senior Planners Anna Stoner and Natalie Earle, and Senior Conservation Design Officer Jamil Kishore will be joining us remotely. We also are helped by Kelly McKenzie from Democratic Services. For the emergency evacuation procedure, there are no anticipated fire alarms tonight, so if it goes off, it's genuine, and please follow the normal directions and meet in the car park, not using any lifts. And is there anyone, I don't think there's anyone who can't get out, so personally present, so yeah, we will move if the bell goes. Right, are there any apologies for absence?
Thank you, Chair. Apologies from Councillor Mike Henderson and Councillor Mike Whiting, who is in attendance remotely, and Councillor Tony Winklis. Thank you.
Just a point, I noticed that I believe Councillor Monique Bonny is on.
I'm here, I'm online.
Welcome. Thank you. So first item is the minutes from the virtual meeting held on Monday, the 20th of February. Does anybody have any issues with the minutes, or are we happy to approve this as a correct record? I'll take that as agreed. Thank you. Are there any declarations of interest? Good. Right, so we move on to item 7, which are the terms of reference for the working group. And if I could ask Jill Peat to introduce this. Thank you.
Thank you, Chair. Good evening, everybody. The Policy and Resources Committee is the main decision-making body for emerging planning and transportation policy en route to full council. And as members are aware, the purpose of formal committees is to make decisions based on the information presented to them by officers of the council. However, in the case of planning and transportation policy, especially local plan policy, it's necessary for members to have a greater knowledge and depth of understanding of national policy and local evidence, so that informed decisions can be made when the time comes to discuss the proposed policies at both Policy and Resources Committee and at full council. To help facilitate this, the Planning and Transportation Policy Working Group, this group was set up, and this is the first formal meeting for this administration. The working group acts as an advisory group that makes recommendations to P&R, and groups of this nature are commonplace across the country, and many of those groups have terms of reference. Agreeing terms of reference supports both officers and members as policies and policy documents progress, because it supports a shared understanding of how the working group will operate and sets out expectations for how work will be presented and shared with both members and the wider public. In section 3 of the report before you, I've set out draft terms of reference as a starter for 10. I thought this would be more useful than starting with a blank sheet of paper. And the proposals before you is that we discuss and amend these words as desired, and the outcome is that we can agree, or the group can agree, terms of reference that will guide and support the work of the group as we move forward. Thank you.
Thank you, Jill. Are there any comments on these terms of reference, members? My only comment was that, as set out on the papers, it says the working group is a subcommittee, but in fact we're not a subcommittee. We are just a working group. So we'll need just to amend that one. Are there any parts of this that we should feel there where there's an omission? Anything else that we should be considering? So, if in that case, is this agreed as a set of terms of reference? If people just indicate. Good. Okay. So that's quickly dealt with. And so we're now going on to the agenda item number 8, which is the scheme of delegation and planning committee procedure rules. And if I could ask Jo to introduce this. Thank you.
Thank you very much, Chair. So the report before you sets out the rationale for some proposed changes to the scheme of delegation and the committee procedure rules, and seeks the recommendation of this group that these are considered by the Constitution Working Group. The genesis of these proposed changes is through Planning Improvement Board, which was a group established in March this year to support the newly created Planning Improvement Strategy. And that is attended by senior officers, the leader and deputy leader, the chair and vice chair of planning committee, and the chair and vice chair of planning and transportation policy working group. And in May this year, the Planning Improvement Board asked officers to review current procedures for preparing the planning committee agenda to ensure effective use of time and that we were making the best use of delegations. So at the heart of that review were principles around having legitimate planning reasons for applications to be included on the committee agenda and for those items to be in the public interest. Government advice, sensibly so, is that planning applications that raise no significant planning issues aren't delayed unnecessarily, and that resources are appropriately concentrated on the applications of greater significance to the local area, which is what we hope those proposed changes will achieve. So then in July 2023, Planning Improvement Board considered the tables in this report before you, the consequent proposals for amendments to the scheme of delegation and the committee procedure rules, and they approved those for onward recommendation to Planning and Transportation Policy Working Group, and then, as I say, onwards to the Constitution Working Group before they would be formally adopted. The table hopefully is quite self-explanatory. The left-hand column sets out what the Constitution or the procedure rules currently say. The middle column is the proposed change. So additions are shown in red, deletions are shown is strike through. And then on the right-hand side is the rationale. So the reason why we are proposing to make these changes. I won't go through those one by one, but if you've got any particular questions or queries, more than happy to do my best to answer them. Thank you.
Thank you. Right, so are there any comments on any of the sections of this report? James first and then Elliot.
Thanks. I've got a few bits as we go through with the actual changes, but the first question I've got is it's the first time that I've seen it written about a planning improvement board, and that it being set up in March. I'm just wondering who agreed to set up the board. If we're in a cabinet system, it should have gone to a committee at some time to agree that there is a board that's going to be looking at this. So has that been done, and when was it done? Who was it?
Are you able to answer that?
In a word, no. So that board was established before I took on the role as interim head of planning. So that board was already meeting when I came to the post. I can absolutely look into that for you and get you some answers after the meeting, but no, I'm afraid I can't answer that tonight.
Thanks, Jeff. I can come back then, because it's just a bit of a concern that we've got almost what is a working group that hasn't been set up officially by a committee that's coming to us to say what they think we should do. And I agree with looking at what is being done, but when we have in here that the Planning Improvement Board in May 23 agreed to review the current procedures, it would just be good to know whether they're allowed to agree these procedures and make these changes, and that they consider the consequent proposals for amendments to the scheme. And it's, you know, who gave these considerations. So there's just questions I think we need to be careful of and make sure that in the committee system we are actually getting things come forward and being done properly.
I think that's why it's come to this group to start that process, because I think there's been these things start from somewhere, and then we're going to go through several stages at this point. So I think there will be adequate scrutiny of these changes. But I think the Planning Improvement Board effectively is members of the administration beginning to formulate ideas, but anything that comes through that will go through all the procedures, so that there should be adequate scrutiny of the any suggestions that are made, and we're the first stage of that public scrutiny of these suggestions.
Yeah, thanks for that. And I'll say I completely I agree with it. It's just that if things are being done, we should make sure it is done for a committee to start with, which would have been good to bring it to this committee first. And just going on to some of the parts of the changes, there's one on page 12, got it as, which is in table 1, and it's number 2, and it's where the parish councils having their responses within the 21-day consultation, which I agree with. Everything should come through, but I just wonder how it would work with parish councils when the consultation is published days after a parish meeting, because parish councils generally meet once a month. And if a consultation comes out the day after they meet, a lot of the time, I remember when I was on a parish council, them asking for an extension and to get their comments back in. If we're going to start being stricter on that 21 days, we need to just consider how parish councils are going to deal with that. If we do give them leeway, whether that opens up other questions for other people saying, well, we can do it outside the 21 days.
Joe, if you could answer on that.
Thank you. Yeah. So this is less about setting the time limit and more about tightening the wording, because the previous wording referred to specified representation period, which kind of meant nothing to no one. So this is clear what that period is. We met with some of the parishes yesterday, and we were talking about other things, and the parishes did mention sometimes the timescales don't work with their cycles. And our response is always, if you can ask us early for an extension of time, we'll absolutely do our best to accommodate that. So that doesn't change. We're still keen to accommodate as and when we can and when we need to, but it's just tightening that wording so that that specified representation period means something. Thank you.
Okay, great. Thanks. All right, Carrie, I've got a few on this table. Should I just go through them? Yeah. And do you want me to do it individually, or should I do a few and then let you answer?
Why not do a few?
Do a few, yeah. You can, they're not that hard. In the table number 4, it just says about the public interest test. It'd just be good to know what is the public interest test and who determines it. Is it a set list that we can actually work from to know that what is going to be agreed to go through or not? On 5, this is writing to the town and parish councils to notify them the application will not be reported to the planning committee. And I'm just wondering if that's even needed at all. If we're setting clear guidelines for them, they know that they need to get comments in by a certain time. So to then, and to give, I think this one is if they haven't given a valid reason for it to be reported. If they know these guidelines, then surely we could probably just take this one out altogether and not have the time of writing to them to tell them it's not going to go. Either do it properly or they don't. And the next one was on 10. And this is just to be clear on what lobbying is. We get some briefings by applicants sometimes when there's a large thing, and I think you just need to be clear, is that seen as lobbying? Because we've got a developer that's sitting down with members. If we need to start saying at meetings every single thing we may have gone through, everyone could have been at that meeting, and it's just being clear what it is. And on 11, no problem with the recorded votes. But just a question again is just does that take up more time at planning committee if we're going to have to start going through everybody? We're trying to speed things up and cut things down. This seems to be something that's adding to it. I've got a couple of other bits, but I don't know if you want to do those first.
Perhaps you could do those, and then maybe I'll let someone else. We'll come back to you for your final ones.
Thank you, Chair. So with your query around the public interest test, yes, let's put some wording in there to be clear on what that is, again, in the interest of helping everybody to better understand. 5, do we need to write to the parishes to explain? I've got no particularly strong feelings either way on that. I suppose it is a capacity building and a training opportunity. If a parish has presented a reason that isn't a relevant planning reason, but they still wanted that to be put forward, it may help them if we write back and explain why that isn't the case. But agree, yes, it could be time consuming in other circumstances. 10 around what is lobbying, yes, again, agree with you. Officers are working on a draft member developer protocol to set out how, when and why it's appropriate for members to engage with developers. And I think as part of that, we would need to be very clear what constitutes lobbying. So what members are being asked to declare at the start of planning committee. So there would be something codified that members could refer to for that. Recorded votes, again, that's not something I have particularly strong feelings on. That, I believe, was a member suggestion, advantages and disadvantages. So I very much willing to listen to views on those. Thank you.
Okay, Elliot.
Thank you, Chair. Councillor Hunt covered point 2 quite well. I think we should be concerned about parish councils not having enough time, but as we said, we always work with them to extension of time. I don't think my parish council's ever struggled to get an extension of time. But I think it does conflict a bit with the change in 5, where the parish council is not going to be reported to the planning committee, should engage with the ward councillor. If the 21-day period's passed, can the ward councillor then still try to come back in? I'd hate to see applications slip through that perhaps should come before planning committee. And what else have I got on this? I think it's important that we do have recorded votes. I think some people can read list of 17 names quite quickly, so And as it says, it's open and transparent. We've got on number 9 about household applications. I do think we've had a lot of applications come for us that have been a waste of time and have sailed straight through. And a lot of them shouldn't come for, but I do think we should have some sort of mechanism with a really high threshold, because there is the occasional exceptional property, perhaps an eco home, or sometimes that we want reported here. So I think we should look at a high bar, but perhaps this well, the door's shut, isn't it? Here, you can't bring a household unless, of course, you can convince the head of planning that it meets the public interest. So I think it's something to look at. Thank you.
Julian, Councillor Speed.
Thank you, Chairman. A number of my points have already been raised, actually, but I concur with the points that have been made about parish councils. I mean, my parish council meets once a month, and if we do receive an application the day after the meeting, the deadline has passed before we have our next meeting. Now, at the moment, the process is we ask officers for an extension, and they're always very flexible about granting that. I'm just a bit concerned that this new wording seems to remove that flexibility, because it basically stipulates that the representations must be received during the statutory consultation period. So I would like to see something added to the effect of all within any extension period agreed by officers, such as consent not to be unreasonably withheld or delayed, because I think it needs to be clear that parish councils are allowed more than 21 days to comment. And I think particularly given the slowness with which decisions are being reached, it's unreasonable to expect parish councils to respond within 21 days if they don't have a scheduled meeting, and we can't keep holding extraordinary general meetings, extraordinary meetings just to discuss one planning application, particularly given how many planning applications we have at the moment.
Julian, perhaps if we could just see, is there general agreement on wording like that we recommend that we should put that forward as a consent?
Okay, thank you. I also think where parish councils are concerned, we should add that where a parish council does call in an application, they are expected to attend the planning committee to outline their objection. Because I've seen cases where parish councils have called applications in and then they don't bother to turn up to the planning committee, and I think it should be made clear to them that that is something they should do. Point 3, the recommendation is to strike out the provision that where there are 3 letters of representation and the ward member requests that the application is called in, that should no longer apply. I don't agree with that. I think if there are 3 or more objection letters from residents and the ward member calls it in, and the head of planning, as provided by these proposals, has agreed that the grounds are relevant planning grounds, then I think the application should be called in. The rationale for this is that the requirement puts the onus on officers to inform ward members, and this causes delay and increases administration. I don't actually recall ever being informed my officers about resident objections, so I don't think this is something that causes increased admin, and it seems to me designed more to disenfranchise residents. So I don't think that's a reason to remove this clause. Under point 9, I agree with Councillor Jays. I mean, this seems to be prescribing that no household applications can be referred to the planning committee. I agree far too many are at the moment, and some of them don't need to come before the committee, but to prohibit them in their entirety is going too far, I think. There may be sound planning reasons for an application to be subject to committee scrutiny, and I think a lot of the measures elsewhere in this document will restrict the volume referred to the committee, but I don't think there should be a blanket prescription of any household applications being brought before us. Item 12. I'm very uncomfortable with this. Members who vote contrary to the officer's recommendation are to provide in writing to the head of planning their reasons for taking a contrary view. This seems to be a bit onerous to me. It seems to be skewing the process in favour of agreeing with officers. I think as members, we're accountable to our electorate. We're not accountable to officers. This effectively means we're reporting to officers. So I'm not comfortable with this, and I do find the comment that this would provide the additional benefit of being used as a basis to determine additional training needs as a bit patronising. And references made to engagement with officers being the most beneficial way. It's not actually that easy to get hold of officers at the moment, particularly on the phone. Then under 13, I think it would be worth clarifying in terms of members of the public about their behaviour. We have had recent instances where there's been quite a disruption from the public gallery, and I think the chairman should inform any members of the public present that if they disrupt a meeting, they will receive a warning, and if they ignore that warning, the chairman reserves the right to expel them from the chamber. I'm also not entirely comfortable with the restriction on representations if a matter is deferred to a site visit. There may be no further opportunity to speak on the matter when it comes back to the planning committee. It may be that new matters have come to light since the original representation was made to the first planning committee meeting. And it also means that important representations may be a dim and distant memory at the point at which the decision is made. So I'm not clear why parish councils and residents are not allowed to address the final meeting at which the decision is made. Thank you.
I'd read that as the opposite. That they were, I thought at the moment they weren't allowed to come back at the time of the committee, but this was allowing it. Is that the case?
Yes, thank you, Chair. That's the intent behind the point, is that they can speak on all 3 occasions rather than having to choose 2 of the 3.
No, what it says is members of the public may speak both at this meeting and at the site meeting, but there'll be no further opportunity to speak on the matter when it comes back to the planning committee for final determination. That is the recommended new wording, which in fact is the same as the old wording.
So it's struck through. So the left-hand column is the previous wording, and the middle column is
It's not struck through on the.
I think we're looking at 2 different sections. We're looking at 13 and 14. I think if we look at
I was talking
14, you're looking at 13, aren't you, Julian?
I was looking at 13, yes.
I think there is a conflict between the 2 sections there.
And just to confirm, if I may, 14 is, if you like, supersedes or adds to the changes in 13. So absolutely, it's our intention to provide additional opportunities to speak. When that works its way through into one set of single changes, that will be clearer. Apologies.
Right. Okay. Sorry that it's not clear. So the intention is that they would be allowed to. Yeah. Okay. Fine. Good.
Joe, could you perhaps come back on any of those points at this stage?
Thank you. If I may, on point 13, we had discussed having something in there around behaviour from the public gallery. Ultimately, we landed with, we didn't want to set a negative tone and assume negative behaviour, and that the chair of any meeting had the discretion to warn or to eject anyone from the public gallery. Again, open to discussion on that, but that was the rationale for why it wasn't included, so that we didn't set out to people that we believed they may behave in a negative fashion. I haven't got any particular comments on the other points raised. Thank you.
I think perhaps at some point we'll come back to the end about the need to put the reasons in writing and see whether that's something that was additions we're happy with, but objections we need to perhaps just discuss. Councillor Whiting, I think you'd put your hand up online. I'm afraid I've got slightly limited access to the teams here. Are you both as a point you wanted to make on this?
Yes, thanks, Chairman. I'm much obliged. Thank you very much indeed. Mine's a very quick one because I agree with much of what has been said, and I support what Councillor Jay said earlier as well. There's just a conflict again. It's a little bit conflict of wording. On page 12, at the bottom of the central column, it talks about the head of planning based upon relevant considerations, and the word planning considerations has been struck out. At the bottom of page 13 under point 5, the word planning has been put back in again. And I just wanted to be some clarity about which was the correct version. The version that sits under point 2, where planning has been removed, or under point 5, where planning has been reinstated. Thank you.
Thank you. Yes, so the correct one there is under point 2 with the wording struck through. On point 5, it's illustrating a different point, but I appreciate I haven't carried through the other proposed changes that sit within the wider text for that point. Thank you.
Chairman, if I may just come straight back, Chairman, on that. So I just wonder what the considerations are, what the relevant considerations are, if they're not planning ones.
Please, could you?
Thank you. Again, this has been something that we have debated quite intently internally. It was felt that there may be representations put forwards that were relevant but not related to planning, and we didn't necessarily want to exclude anything coming forward by the specific inclusion of the words planning considerations. So we wanted to leave the door open for people to put representations in with slightly wider context. Thank you.
Councillor Palmer, Richard.
Thank you. I'm also worried on page 12. It says such terms as in the opinion of the head of planning. If something's going to be decided on a relevant planning consideration, then it stands on its facts, not on the opinion of someone. The opinion of someone is very vague. I don't think that you should ever use the word opinion. I do agree with recorded votes. I think it's a good use of democracy. I think planning is one of the most contentious issues that our residents face. And I think more transparency is a good thing. I also feel that it's a bit of, I think Councillor Speed was quite, I think the householders application, whether it's for 50 houses or 100 houses, if it's referred to the committee on relevant planning grounds, that should stand. Last Thursday at planning, I had to highlight that I feel there's a discriminatory practice against householders. And I think this council sometimes needs to think how it does manage some of its applications, because, and if we put in there that it can't be called by a ward member to the planning application, then I think I certainly couldn't support that and wouldn't support it. I think with lobbying, it's very vague, isn't it? You've got to be clear, because I walk up the co-op, when there's a contentious application, I face a lot of lobbying. And that's on the way up and on the way back and in the shop. What do you class as lobbying? Because you may finish up with a planning committee that can't actually sit because everyone's been part of lobbying. So that isn't clear. There is clear definitions in law of how a planning decision is made. And it is based on the relevant information and the weight that the decision maker applies to the information that's provided at the time of the planning committee. When I come to a planning committee, I have a clear mind and I base it on the relevant facts as presented. Whether I've had emails from residents, whether I've had emails from developers or third parties or anybody else, I base the decision, and that's what we should all be doing. And to put something like that is sort of saying we are making decisions based on what people say to us. We base the decisions on the weight of the evidence or the facts presented to us. And that's how it should be. And I think, yes, I think it should be the chair's decision to whether they throw somebody out or people if it gets rowdy. And that doesn't just apply to planning, it applies to any meeting of the council. So it would be a bit strange to have that for planning, but not for anywhere else. I think vague words don't help. It's got to be clear. I don't know if it's worth deciding this tonight or getting it rewritten in such a way that it is clear and it's clear for the parish councils. I fully support. I think the parish councils feel that this council is against them at some times. And I think to have words, you know, if you want to give them an extension, then make sure it's clear in the report of what we're voting on. And yeah, and I think if 3 letters from as it's been have arrived and they're clear, sound planning reasons, then it should perhaps come to the committee. It's as simple as that. I don't think there needs to be much change, but using vague words like "in the opinion of," because if we start going down that line, it could be very interesting. Thank you.
I think it's Councillor Jay's next, and then Councillor Bonney online, and then. Yeah.
Thank you for allowing me to come back, Chair. On what Councillor Palmer said, the opinion of head of planning, that's been in the Constitution since we started on the council, so that's always been there. I think going back to point 2, perhaps we should put under superseding legislation or where extensions agreed to make it clear. I think Constitution has to be clear on what, and so it's easily understood by parish councils. On point 3, perhaps when when letters of representation are sent in or logged on the portal, perhaps you should bounce back and say that it'd be advisable to contact your ward councillor, because without contacting them, it's not going to go to planning committee. The reason why I think it's been asked for people who have contrary opinions to submit in writing within 7 days, the reason why they've gone against is to strengthen a certain appeal. I've sat on a few appeals, and the inspector likes to hear clear reasoning. He likes to see items minuted, or they would like to see items minuted. We spoke about household applications. One step down from no household applications would be that if it was agreed by the chair or vice chair to go on the agenda, or we could set a number of all councillors as we did for call-ins for scrutiny, which was at 5. I think this is something we should ask P&R to look at, as then where this is going next. Yes, perhaps we should set it at maybe 3 ward councillors, because there are certain ward councillors that seem to call in anything a resident asks them to, and there's a lot more of us that are more reluctant because we understand the planning system. I think on number 13, just to make it very clear, we should strike through on the last 5 lines. And I think that'd clear up the confusion we had earlier. I think that's all I've got, Chair. Thank you.
Thank you. Councillor Bonney online.
Cheers, thank you. So there's a couple of things. Can you hear me?
Very loud and clear.
Oh, good, lovely. So I'm pleased that parish councils will get the opportunity to speak when the item is finally debated, subject to any site visits or adjournments. I think that's positive. There's a couple of things that I query. One of them, so around item 13, the chair will welcome members and blah, blah, and has the right effectively to remove anyone. I think the chair already has that right. I know I've made inquiries with the monitoring officer, especially with regards to the conduct of members or anyone at a meeting if they are disruptive or intoxicated. So I just want to make sure that the wording that's put in here won't conflict, or we won't have any conflict with that code of conduct or the Constitution. We need to make sure that they all marry up, or delete it from this and rely on the wording that's in there. And final bit, I mean, this is a working group, so I presume that this is the recommendation is that this will go to P&R for adoption, and so there'll be further discussion on this at that point.
I think this will be going to the Constitution Working Group next.
Yeah. Yes, sorry, apologies. Yes, that's what. Yeah.
Councillor Watson, Karen.
Tell I haven't spoken at a committee that often. Majority of the points I wanted to bring up have already been brought up, Chair, by my esteemed colleagues, and I would agree with everything that they suggested. I do agree with the if the parish or town council calls something in, they should be encouraged to attend to planning committees. I have sat here and they've called an item in and haven't turned up. So I think if you've called it in, at least turn up. Members being asked at the start of the committee about lobbying. I think perhaps a document of some kind that come out that would define lobbying to all of us who sit on planning or are eligible to sit on planning might be useful. As was mentioned, is lobbying being invited to a briefing? Is lobbying when you're in the co-op getting your loaf of bread and someone saying, oh, you're the councillor, there's this application coming up. So I think we need to be a bit clearer on that. And yes, the chairman does have the power to take people out of the public gallery or ask them to leave. But I also think it isn't just the abuse that perhaps the councillors get, it's also the abuse some of the officers get too. So we should be protecting them as well as us, which I know we would, but I think we do need to make that clear, or a bit clearer than we have done. As for getting recorded votes, that's really for transparency, and it's something that, you know, we are accountable to our residents of not just our wards, but of our borough. And there was one other point I was going to make. Yes. So the voting contrary to the officer's recommendation. At my first planning committee here, we voted against what the officer's recommendation. It's very daunting having to write to the head of planning for your reasons as to why you voted against, but it's a good exercise for us ourselves to actually show that we do understand the consequences of our recommendations, and we don't just put our hands up because we feel like it. Otherwise, I totally agree with everything that's been said by everybody else on the committee. Thank you, Chair.
Thank you. I think the one on providing reasons in writing, I think is probably one of the contentious. Is there a sort of view in the group whether that should be in, or we should not have that one? So people can indicate if they are in favour of providing reasons in writing, just so we can send the view of the group.
Chair.
Yep.
Sorry, could I ask a question on that?
By all means.
So on that, I mean, we're putting an obligation on the members to do that. If they don't, what is the consequence?
I don't know, but I suppose we can be requested. But Councillor Hunt, you want to come back on this?
So I was going to come back on some other bits as well, but on this one, I think you'll come back to standards. If you don't do what you're asked, then it's standards that you're not showing leadership and all the other stuff.
Councillor Palmer.
Well, on that point, I think Councillor Speed put it quite right. We are the representatives and we are the voice sometimes of our residents. We're accountable to our residents, and that's who we should be accountable for, not to the head of planning. And I think if there's an interference in that, by saying you have to write to the head of planning to explain why you voted in such a way, I think that's an interference with democracy.
Councillor Jays.
Just to counter that, when we're a planning committee, we have our quasi-judicial role. So I think it's important to remember we're there to form that justice role. We're second as councillors on that. I think the idea of writing to the head of planning is, yes, it'll be addressed to the head of planning, but it's for any planning officer to strengthen our case at appeal.
And finally on this one, Councillor Palmer.
If I just come back on that, I have raised it. The Court of Appeal has already made clear that planning committees are not quasi-judicial. It's something this council keeps insisting that it is. And I can send the Court of Appeal ruling, but I have sent it many times and I've even sent it to legal. So it's quite clear that planning is not a quasi-judicial, and that's even in the local government association. So I think if we're going to quote that it's quasi-judicial, then I think we need to be very careful because it's not. And they've been quite clear on that. So I think it needs to be drawn a line under. Thank you.
Point made. Okay, Councillor Hunt.
So I've just got a couple of it. On that one still, there's just something else that I wanted to raise on that anyway, because my personal view on it is that every member that votes against something should have a valid reason anyway, otherwise you shouldn't be voting against something. And if you just think it should be refused, then you're not doing it right. But a concern, I agree that I think it should be written down because there should be no issue in it. But I've also got a concern with it that if we are doing this because of getting things to help with an appeal, whether there's a member that has voted against it but has got a different reason for what was actually given at committee. And if you start putting other reasons in there and trying to bring that to appeal, you could have then cost against us because of being unreasonable, trying to throw an extra thing in there which hasn't been agreed by the committee, if that makes sense.
I think I'm getting the consensus that there are some workability issues around this proposal, that maybe it needs a bit more refinement before we could really agree to recommend it. Is that a consensus issue on that one? The principle of providing good reasons in some form or other, I think it does stand. Councillor, you had anything else? But
yeah.
we can quickly.
Just a couple of just going back over the household applications. It's a difficult one because there are so many household applications that come that we don't need, and as a ward member, sometimes I think I would wish we don't even get involved in household applications. I mean, why do we want to get involved with a neighbour doesn't like something another neighbour's doing when they're just doing an extension? Puts us in the middle of things. But I do like the idea of having 3 members agree to call something in. So there is still something that can be done.
3 members or 3
It was 3 ward members that Councillor Jay said about that if there is a household application, rather than a member calling it in, having 3 ward members to be able to say that comes in, because that does give a bit more of a working of there may be other ward members that don't agree. Or if a councillor is in the middle of some residents, to say this off of mic really, but you can have a word with the other ward members to say don't agree it for me, because you can still look at it doing what's right for residents, but make sure it doesn't come to committee.
Is that a danger of being almost a sort of mini planning committee?
Well, it's not, but it's you don't want to get involved in thing, and if there is going to cause that of still being involved, then have it as is being proposed and don't have it come into committee at all. But there is these problems where you do get stuck in the middle of almost neighbourly disputes because someone doesn't want an extension. But why would we want to sit here when someone is trying to build something, an extension, so they can stay there in their family home for many years, and somebody next door doesn't want it because it might cause a bit of light. So it's just where we get involved as ward members sometimes. I don't think we need to be.
Would that be a compromise about the suggestion that household members are only household ones are as a routine, not brought to committee, but only if there are exceptional the issue that Councillor Jays was saying about there's exceptional reasons, then there would be, and that could come under that side of that exceptionality suggestion as being the one reason that a household would come to the committee. There's got to be something special about it before it does. Yeah. And that the routine would be.
I think you need something to not completely rule every single one out, but something all does need to come through there. And just one other point was the parish councils having to attend committee. I've got a slightly different view on that because I agree it's annoying sometimes when parish councils don't come along. But I also understand that we have to think that parish councillors are volunteers. And if you've got a parish councillor completely the other end of the borough that needs to come in when they're trying to deal with family and everybody else to come over here for 3 minutes to say something that's already been written down is a bit of a concern. So I don't think they should be made to come to committee, but encouraged.
I don't think there was a proposal for a compulsion. Councillor Palmer, and the final issue on this one.
Again, the only trouble is with trying to define exceptional. Do we have a list of exceptional, and who decides exceptional? So what I feel might be exceptional, somebody else might not. That's the only trouble with words. I just think, you know, if I've had people ask me and say my neighbour's putting this up, I don't call it in, I don't get involved. I say it's down to, it'll be decided by the planning officer or the committee if enough people complain. So that's the way I deal with it. If I feel there's an injustice or there's something that should be called in and there's reasonable grounds, I call it in. It's as simple as that.
So on there and perhaps.
Yeah, thank you. So I've done my best to capture all the points in my notes. I will cross-reference them with Kelly's notes. Yeah, thank you. Thank you very much. That was a really useful debate.
Chairman, sorry.
Councillor Bonney.
Sorry, I did have my hand up. Unusually.
Sorry, we've got a limited IT problem. So.
It's all right. Okay, briefly, I hear what James is saying and Richard about the householder ones. I suppose my problem is with 3 ward members. I'm in a really rural area. We've only got 1, and when you get out into the, you know, more into the sticks, you know, member coverage is quite thin on the ground, and it would make that feel like a very sort of urban mechanism, as it were. I do agree that routinely householder ones shouldn't come before the council, but I think there does need to be a mechanism for an exception. I mean, I can't think of any that I've called in, certainly not recently, but I think there should be a mechanism in there that a member can, and I think 3 members is probably stretching it. That's all I wanted to say. Thanks.
Okay, I think if we can, oh, sorry.
Sorry, Chair, I was just going to ask about the process next, because it's obviously going to the Constitution Working Group, but is there any, would it come back to us at all once this is done? Because if not, I'd propose that once the Constitution Working Group has looked at it, it comes back to us to have that final look at it once it's in a almost final state, so we can then sort of have a look at what we've said tonight, whether that's in there and whether there's anything that all needs adjusting then.
I think I need to defer to Democratic Services on this one, whether the route is set out for these reports to be reconsidered once they're at the gone through the Constitutional Working Group. Okay, I think that probably would be. I think this is a fairly fundamental thing. I think it's, yeah, we will ask for it to come back.
It says here to recommend it. If we don't recommend it, I suppose it'd have to be rewritten and come back here.
Well, we've made some recommendations to alter it, so I think we need to see what the final thing is before we can recommend it. Which in fact probably leads us, I think, neatly on to the next one, which was something we have already debated.
Just a suggestion, would it be preferable for it to come back here before it goes to Constitution Working Group? Because I think Constitution Working Group is normally pretty final. If we want to have another look at it here, let's get it right before we take it there, perhaps.
Okay, if we can have a report at the next committee meeting with the amendments incorporated, and then we will, hopefully we won't need to re-debate it all, but
Yep.
can just see that what we've said has been captured.
Thank you.
Which I think brings us on to the next agenda item, which is the local plan. Just check that one. Local plan review next steps discussion paper, which is actually something we have discussed in our informal meeting, and so I hope this is really just as a check that what is going to be passed on to PNR is what we've agreed. But if Jill could present the meeting for the benefit of those who members of the public or who weren't there, as to what we're going to be recommending.
Thank you, Chair. In October last year, a report was presented to Policy and Resources Committee to pause plans to undertake formal consultation on the local plan review. This was in light of the uncertainty at the national level. So now is a really good time to take stock, and the report before you seeks to set out options for next steps. There are 5 options set out in the report, along with their various pros and cons. These have indeed been discussed informally, and a summary of the points raised is contained in section 5 of the draft report that will go to Policy and Resources next month. That's contained in the appendix of agenda item 9. The conclusions of the discussion that was held informally supported a hybrid of options 2 and 4. And the recommendation is that members consider the content of the report and agree the working group's preferred option for progressing with the local plan review. This is to recommend to Policy and Resources that members defer a decision as to the timescale for the future stages of the local plan review until such time as the national planning landscape is clearer, but independent of this process, proceed to develop the evidence base regarding local development need and potential, with this process to be wholly reflective of local circumstances rather than central targets. Thank you.
So as I say, we did debate this informally, and it's really just a question that this is a accurate reflection of what we wanted to recommend. James.
I agree, but I haven't got as much as the last one. There's just one thing in here in 2.1. There is something that's said that I just want to clarify, because we were told something different in a previous training session, and that it says that without an up-to-date local plan, reduced weight can be given and the presumption in favour of sustainable development applies. At a training session recently, we were told that that only counts that the local plan is out of date if we haven't got a 5-year supply. So the question is, again, if we have got a 5-year supply, is the plan out of date or not? Because this is saying that it is out of date. And the other point I've got on this one is that we're saying that there isn't a timescale until it's clearer in planning what government are doing. But on page 29 at 2.19, it says, depending on the steer from members, adoption would be likely to be 2025. Consequently, it would be prudent to extend the local plan period to 2040. That's almost giving a timescale there. If we're saying that it's likely to be 2025, well, how can we give a timescale in that when we don't know what the national picture is going to be like?
I'll defer to Jill for most of this, but I would hope that the government will have got their act together by that stage. Question of which government, I suppose.
Thank you very much. I hope I've captured all of that. I'll deal with the issue around adoption by 2025 first. We are currently in a position where the government is looking to introduce a brand new planning approach for how we do local plans. So if we want to produce a local plan under the current system, we can do so under the transitional arrangements. but we have to adhere to the set timescales. So if we don't submit a plan for examine next year, we will not be able to have a local plan. We'll have to wait and do a local plan under the new system. It's basic. I mean, basically, we've got a lot of evidence already prepared. We're continuing with other work. If there is a consensus, as far as I understand, that we do want to progress with a local plan review, and that we want to do that under the transitional arrangements of the current system. I think it's absolutely reasonable that we continue to keep an eye on this and take stock. And it may be that further down the line, members decide actually we want to be one of the front runners in the new system. But the longer we don't have an up-to-date local plan, the longer we remain vulnerable to speculative development. And the other question was about, is the local plan out of date, and does that result in the application of NPPF paragraph 11D footnote 6, the tilted balance, the presumption in favour of sustainable development?
Basically, is the local plan out of date, whether we've got 5-year supply or not?
I can confirm that the local plan is out of date, regardless of the position with 5-year housing land supply. Where it gets even more complicated is in relation to the amount of weight you might give to the policies that are out of date. So it's all a question of weight to be applied, and the person that makes that judgment is the case officer, and that will depend on the individual circumstances of the proposals. Thank you.
Mr. Palmer.
Yeah, just coming back on that point, I quite agree with what Jill says in some respects, but I think it's quite clear that policies aren't out of date. Policies can be given weight if they are relevant, and it's also the decision maker who decides the weight. It's right for a planning officer to draw attention to weight, but a decision maker, which is the planning committee, can decide, well, you make your own mind up what way is that way and what way is that way, whether it's in favour or you can vote against it, because the weight you put on something as the decision maker is the key fact, not what the officer says. I just wanted to make that clear, so it didn't lead to a bit of confusion. But you explained it quite well, that the policies, but the policies aren't out of date, but they might be. It's up to us to prove that they're still in date at the time.
Right. Oh, almost there. Councillor Jays.
Thank you, Chair. I think what we're sending forwards as a recommendation is more a hybrid of 1, 2 and 4. We need greater clarity, but obviously this year we've got the King's Speech coming up. We've got an autumn statement, so we can probably expect some red meat ahead of the next general election, as well as the new NPPF. So I think the future's looking interesting.
So,
Sorry to come back, because if you're saying that it's also a thing of two, and this is where I think the confusion is, because if we are going down the route of saying that we want to try and do this within the transitional arrangement and not afterwards, then that is a timescale. And to say that the recommendation to P&R is that we don't go ahead until the national planning landscape is clearer, I would say is wrong, because what we're saying is go ahead to get it done under the transitional arrangements.
I think we're saying about not going through the formal stages until those, we're continuing to work on it, but not necessarily progress with the formal stages of the plan, is how I'd interpreted that.
Chair.
Councillor Bonney.
Sorry. So just to be clear, question to Jill. The transitional arrangements, if you're using the transitional process, is there not an onus on us to adopt the central housing target under those additional arrangements?
Thank you, Councillor Bonney. That's a great question. And I'm trying to think how best to answer it. Certainly, I think it's fair to say that the government expectation is that local planning authorities up and down the country will do their very, very best to meet their full local housing need. And we have concerns about our ability to do that. We've been very vocal about those concerns, both sort of officers and members. And whatever we do, whether we progress with a local plan review under the transitional arrangements or we progress with a local plan under the new system, we must be in a position where our evidence is robust and we can demonstrate what we can or cannot deliver. And that is the main focus of work for the planning policy team at the moment. We are carrying out very detailed site assessments of all sites that have been presented to us for consideration, as well as existing undeveloped sites in the current local plan and any other parcels of land that we are aware of that merit consideration. And what this will do will provide us with a capacity approach rather than a numbers game, if I may. And that work, all being well, that work should be ready for publication in the new year. And I think at that point we'll have a much stronger picture of what the capacity of the borough is. But it is my understanding that there is a void in emerging government thinking around what is going to happen to housing numbers, bearing in mind that we think anecdotally and that it's likely that we will be expected to do our best, but it doesn't answer the question of what happens to the houses that we haven't been building over the last 30 years, and recognising that we are in the midst of a housing crisis. So there's a lot of unanswered questions, and I'm sorry I've been a bit waffly there, but I just wanted very much for you to try and have a complete picture.
I think in terms of the recommendations, though, we're not referencing the transitional arrangements in the recommendations. So I think in terms of what we sent forward, I think I feel we can send this paper forward to Policy and Resources to make a decision.
I agree.
Thank you. Right. If we can move on to agenda item 10, which is okay, I've been prompted to ask someone to move and second that we make this recommendation. Councillor Palmer. Councillor Watson seconded. So, and everyone in favour to make this recommendation? Not that it's a decision. Right.
Thank you, Chair.
This item covers partnership working between the Environment Agency and Swale Borough Council on programme delivery for the Medway Estuary and Swale Coastal Flood Risk Management Strategy, abbreviated as the MEAS. The MEAS was approved in 2019 and followed on from the 2 shoreline management plans for the area. The MEAS is led by the Environment Agency and seeks to reduce flood and coastal erosion to properties and infrastructure around Swale and the Medway Estuary in a sustainable way. The EA are now working on a programme delivery for the first 10 years of the strategy and are seeking partnerships with organisations such as ourselves, Medway Council, Tunbridge and Moreland Council, Kent County Council and Natural England. Within Swale, the first projects of the 10-year plan are schemes for Sheerness and Queenborough, as well as South Sheppey. Following on from these will be schemes for Sittingbourne, Faversham, Lower Halstow and Tailness. The recommendation is that the working group notes the proposed approach regarding partnership working on the MEAS and that the working group recommends to Policy and Resources Committee that the council joins the partnership. Thank you.
Thank you. Does anyone have any questions on this report? Councillor Jays.
Thank you, Chair. It mentions about us recommending to Policy and Resources that the council joins the partnership. Does that mean we'll be sending council representatives to it? Or is it just the officer?
My understanding is that it's just My understanding is it's just officers at this stage.
Okay, so for us to have any impact, we'll have to feed back to an officer, because I know that under 2.4, the map below shows most of the island underwater or a tidal floodplain, and it mentions a report about preventing erosion, but as usual, the Environment Agency are failing to do anything to stop the North Shore eroding. It'd be nice if the Environment Agency would create a footpath along there and use some dredging or spoil from one of the many projects that come out of London. It's been done elsewhere. The Channel Tunnel spoil has built a lovely area of recreation. I know there's various members and outside bodies that would love to see something done along here. I think it'd be excellent for our walking and cycling strategies and increase tourism. I think we should join the partnership, but I think we need to be a strong and vocal partner, because the Environment Agency have walked all over residents for far too long. They do far too little for residents of this borough, but I do agree we should join the partnership.
Councillor Hunt.
Thanks. I agree as well. I have actually been to quite a few of the meetings when they started looking at the areas around Iwade. It was when I was chair of Iwade Parish Council. I've been to quite a few of the meetings, and they are good, and we should definitely do it. And I've got no issue if it is just officers as well going along. But the only question I've got is, why has this come to this committee? It just seems a bit of a process to bring it to us for noting and agreeing it to P&R, when it probably could have just gone straight to P&R and asked them to agree to do it.
Noted. Okay. Councillor Bonney.
Cheers. Thank you. I'm just wondering, are the Lower Medway Drainage Board included in this? Because I see that they have a significant role here, and as a council, we send representatives to the board.
Yes, they are.
Can we make sure that they're aware of this, that our own representatives, that they're sent this documentation and fully informed?
Yes, we can do that.
Lovely, cheers.
So our members are happy to note this and recommend that we take part in the partnership. Thank you.
Yep.
Right. Next one to agenda item 11, briefing on the Kent County Council's consultation on the draft of the local transport plan for Kent, is LTP 5. I understand the deadline for submission this was yesterday, but we are going to ask if there are any comments from this committee that we can add them to representation that we have. And if I could ask Natalie Earle to present the report.
Thank you, Chair. You will have all seen the report, which is a briefing on the Kent County Council's consultation on their draft local transport plan for Kent, and the annex, which is our Swales consultation response to it. Central government have instructed all local transport authorities, such as Kent County Council, to prepare new transport plans by the end of 2024 to reflect societal and economic changes that have affected it recently. They've affected how and when people travel, why they travel, what transport operations and networks can provide now, and also the priorities that both national and local government have for both travel and transport. So Kent's new plan will help the government to understand the pipeline of their proposals, the funding required, and the contribution these will make to national policy goals and targets, such as reducing carbon emissions. At this stage, the plan is very high level, so it just sets out the direction of travel and the aspirations, but it doesn't contain any detailed proposals. That will come at the next stage, early next year, we think. So at this stage, Swale will need to continue to engage with Kent as they work on their more detailed proposals, and to make sure that it aligns with the aspirations and proposals that we have coming forward with the emerging local plan when that comes forward. As Councillor Gould said just now, the consultation did close yesterday, but we have agreed that we will be able to put any extra comments in that any members have tonight for consideration alongside our main response. So our main response was agreed under delegated authority of the interim head of planning, and the chair and deputy chair of this committee also saw the draft response. So the recommendations tonight are: 1, to note the content of the consultation, and 2, to note Swale Borough Council's views on the consultation document. Thank you, Chair.
Councillor Bonney, have you got a comment on this one?
Sorry, yes. I think I gave some comments previously, but a comment that I've had back from my locals recently, because I think this affects quite a lot of Swale, is the cancellation on the rural bus network due to their savings. And I want it made really clear to Kent County Council that to severely disadvantage the rural areas with no other alternative means of transport is really causing serious issues to our rural communities. In particular, I was talking to a lady, she's 85, and she said to me, since the bus has been cancelled, the service, her mental health has severely declined because she can't get out. The alternative that has been provided by the Kent Carrier Service has meant that she sat on a bus for hours, this so-called, dial a ride. She's got to a destination. She's left with half an hour before she has to return on the adopted time. It is just a ridiculous alternative that is not workable, and that the services that have been put in place for our rural communities have been, that there has been no ambition previously to even make them commercial, to run them at reasonable times that people can attend school, doctor's appointments, shopping, whatever it is they need from their local service centres or towns, or to get out of the borough for work, etc. The services are absolutely atrocious. They have to be practical to the users, and that, I think we've got to absolutely reinforce that they cannot bring in a service that is just totally unworkable for the users.
Yes, we did reflect that in our response, Councillor Bonney, because you came forward with that. So hopefully that is reflected adequately in the response that we submitted yesterday.
Does anyone else have anything they wish to comment? Councillor Jays.
Thank you, Chair. It always makes me laugh when I read growth without gridlock, especially at the moment and up until Christmas, as it is in my ward on the Isle of Sheppey in Minster. In fact, the whole of Minster, you can't go a few hundred metres without traffic lights or a road closure or someone digging up the road. It's growth without gridlock. Makes me laugh. But on this particular item, I agree we've got to respond to KCC, and our residents deserve better from KCC Highways.
Councillor Hunt.
Thanks. I agree with the whole report, but it's just a thing of formality of it. Is that we've been asked to note it, but then we're also being asked at 5.4 to submit any commentary. But then at the beginning of the meeting, when we did our terms of reference, we can only make recommendations to P&R. So how can we, as a committee, make changes to this document?
Please think on that one. I suppose we are a sort of consultation group, and as this could, I think, be an entirely officer led report, was for this sort of consultation. I understand that is the case sometimes for consultations like this, that they don't necessarily have to have member input at all, and so I think we have that sort of possible remit within that, but maybe that's something we need to think about within the general terms of reference.
If I can come back, and that's what I mean. We've agreed in terms of reference, but if we are going to do consultations and have input, we should have included it in the terms of reference. And we heard as well that Councillor Bonney said she's already had input into this. So if there is members already having been involved in something, again, under a committee system, where was it agreed that members can already have involvement? So we're either delegating to officers to do things or members are having involvement. And I think there's just lots of different things. It's not just here, it's still that within the committee system, we're not quite getting things right. I think it just needs considering and being looked at.
Noted. So are we happy that the report goes to KCC as it is? I think there will be a further consultation down the line on this one. This is on their sort of first stage consultation. There will be a further one later. Maybe we can address the issues about procedure when we come to that one. Right. So agenda item, I think we're on to number 13 now. With 12, oops, sorry. Right, this is the enhanced partnership, whether we're going to recommend to take part in the local focus group of the KCC's enhanced partnership hierarchy, which I think is reviewing the bus services so if I could pass over to present this one.
Yeah, thank you very much, Jay. You've got me again for this one. So 2 headline recommendations for this report. That Swale Borough Council set up a local focus group as part of KCC's enhanced partnership hierarchy, and to recommend that the local focus group reports to the PTPWG, with the chair and vice chair of PTPWG attending the LFG, I'm sick of my own acronyms, and the representatives from each of the 4 area committees also attend. So the background to this recommendation: KCC used to manage and run quality bus partnerships in each district. They consisted of KCC and Swale Borough Council members, KCC and Swale Borough Council officer representatives, and the commercial bus operators in Swale. And these were a way of raising local issues, discussing planning applications that may have impact, and any highway or parking related items. It wasn't a statutory requirement, but it was resourced and administered by KCC. These meetings stopped when government started development of its national bus strategy. KCC have received money linked to this, so an indicative allocation of £35 million from the Department of Transport. As part of this funding, government requires that each area, so at KCC level, sets up an enhanced partnership. This is a statutory board without which KCC will not receive that funding. That board has been set up. Sitting beneath that are enhanced partnership scheme monitoring groups. There's 3 within the county. We are part of the East Kent scheme monitoring group, and we have one place at that meeting. These are very high level and do not cover local district issues. And KCC indicate that they feel this will leave a gap. And to fill that gap, they are suggesting enhanced partnership local focus group meetings are set up in each district. They are happy to send representatives, but they cannot resource this like they used to the Quality Bus Partnership. So they are asking districts to set them up and to resource them. These are not a statutory requirement of the hierarchy. Now, KCC think that these would be a replacement for the previous Quality Bus Partnership meetings in that they are aware of local issues from the bus companies being raised. The proposal is that they would be held 6 monthly and that they are informal. A standard agenda could include local bus network issues and aspirations, planning and development updates, parking enforcement issues, and any other items that we chose to raise, such as active travel and air quality. The representatives of those meetings would be the district councils leading and chairing, KCC Public Transport, KCC Planning and Transport, the primary bus operators, and district council officers, subject to the agenda items from planning, parking, active travel and environmental health. And these meetings would be officer-led. It's felt that they could be a way or a good conduit of raising issues to KCC and a way of lobbying for investments in Swale. We need to note that as it stands, Swale Borough Council doesn't have an obvious officer resource that has buses in their remit. So agreeing to set up the local focus group would need to be considered in that context. And linking to that, if members would like that to be agreed and to be set up, it's proposed that it's kept high level, meets twice yearly, and is managed by the Director of Regeneration and Neighbourhoods, who would chair and coordinate that group. So KCC would lead on the updates on that forum. We would be a conduit or an enabler, bringing partners together as opposed to leading or delivering any work directly. In that respect, it would make the resource pressure, we believe, manageable. We would be absolutely clear with all attendees at that meeting the role of SBC within that partnership and the limitations, so that we're not going to be at the vanguard of solving the issues, but we are a conduit to raising them and to having a voice around the table. So it's proposed then that this working group is the conduit for any feedback back to the council. As I mentioned earlier, it's proposed that the chair and vice chair of the PTPWG also attend the local focus group as member representatives, as well as one representative from each area committee who can provide a local voice into the local focus group. And I think I will leave it there. Thank you.
Councillor Bonney.
Cheers, thanks. In the previous guise, I did, in the cabinet system, I did regularly attend the bus quality partnership, and my observation from that, when I first started attending, it was clear that Swale hadn't attended in any proper way for many years. When we did get focus on it, it was good because it did bring together planning and a number of other strings so that problems could be ironed out with the bus operators as well as with KCC. However, under this current setup, I'm very sceptical, as KCC say they've got limited resourcing. I do think, what's the point? Because when the quality partnership was properly attended, which for a long period it wasn't, it was good. But if KCC are saying they haven't really got the resource to it and it's going to be a half-hearted effort, quite frankly, we've got so many working groups. I think we need convincing that it will bring about the changes that we want it to. You know, obviously that's driven by the membership, but if the resourcing, if it's set up to fail, I do wonder what the point of it is.
Councillor Hunt.
Thanks, Chair. As Deputy Cabinet Member of Regeneration, when I used to attend this every single time it was on. So up until 2018, it was well attended because I was there with Mike Knowles and all the bus companies, and it was really good. So I don't know what happened after that, but it was well attended. it was good as well. We managed to get things done, and especially any ward issues. I think there was other councillors that did come along at the time as well when things came up. So I completely agree with everything that's being looked at now and taking something forward to work with the buses. The only question I've got, again on the recommendations, which probably won't be a surprise to anyone, is who are we recommending it to? Because we can only recommend to PNR.
I would recommend that to PNR that they do this in that case. So if we can, is there anyone who wants to propose that as a recommendation? Councillor Hunt, and are people in agreement? Yep. I think we're agreed. Right, so we're now moving on to the conservation area reviews. First of all, it's Bredgar. Can I ask Jamil to introduce these items, starting with Bredgar?
Hello.
Hello, we can hear you. Yeah.
Yes, Chilmil Kishore, Senior Conservation Design Officer. Bredgar Conservation Area, the 6-week public consultation on the document concluded on 14th of August. And we received 3 responses during the consultation process, one from a local resident, one from Historic England, and one from Parish Council. The consultation responses are collated in Appendix 1, and the document has been updated to reflect these responses and is attached as Appendix 2. The amended document reflects changes as per the responses received. There are no boundary changes proposed for Bredgar Conservation Area. However, during the consultation, we received a response asking us to look at outlying areas of Bredgar, and there was a suggestion of whether we could have satellite conservation areas or if we could look at anything very specific. There is no system of satellite conservation areas, but there is an area called Bexon near Bredgar, which we found to be most characterful, coherent, and it comprises 8 statutory listed buildings. So the recommendation today to the working group is that if the working group can agree to the amended document as presented, and whether we should look at assessing Bexon as an additional new conservation area, designating Bexon as a new conservation area, and an assessment would need to be done for that. Shall I move on to Hartlip, or should I take questions before that?
I think it'd be sensible to deal with them individually. My first question would be: are there some resource implications for doing an extended for the other area? Have we got the resources for that?
We will be. Well, simple answer is no. But it depends if the resources are, there are resource implications, yes.
Okay, I can pass over to Joe on this one.
Yeah, if I can just add to that, thank you, Jamil. So we do note in the implications box that these costs aren't yet budgeted for. Obviously, we didn't know the recommendation was arising. So they will need to be considered alongside any future heritage strategy action plans. And that will then be a matter of prioritising the limited funding that we do have and where we should focus that. So there is no specific funding for this activity at this point in time. there is budget that we can look to prioritise this against other competing heritage priorities. Thank you.
Councillor Bonney.
Well, thank you. Yeah, no, I wholly agree with this report and the recommendations. Thank you.
Councillor Hunt.
Yeah, I agree with the two recommendations that we've got to take this forward. And I mean, should look at it more detail, but I personally saw it at the Western Area Committee, and there was a lot of talk on it there, and it was a good document that should go forward. I think with the satellite thing, I don't think we've got a recommendation here to actually take that forward. So I think it's something that needs to be looked at elsewhere.
Noted. So are we willing to recommend that this one goes forward? Thank you. And okay, Jamila, if I could pass you on to do the pass back to you to do these Hartlip one.
Thank you. Bredgar and Hartlip were consulted on together. So public consultation for Hartlip concluded on 14th of August as well. We received 6 responses for our public consultation. All 6 responses were from local residents. And for Hartlip, there are 3 areas which are proposed for boundary changes. If possible, can I share my screen if that makes it easier? Can I share my screen, please?
Kelly, is that possible?
Hi, Jamil. Unfortunately, the IT isn't working properly in the chamber, so we won't be able to see your presentation, I'm afraid.
Okay, no problem.
Ciao.
So, but I can direct
I think
you.
Share your screen on the Teams. I think most of us have.
Our members have got laptops.
Sight
Then,
of
okay.
a screen.
Or
So
you could,
please do
if you
share.
look at page 193 of the pack, that has the boundary changes, the appendix 1, it's page 193 to page 196. It shows the boundary changes proposed for Hartlip Conservation Area. And the very first is to include part of Mount Lane, which is to the south of Hartlip, current Hartlip Conservation Area. It's a very it's a significant rural lane, which I think should ideally form part of the conservation area and would form it completely. And the second change is to include Cuckoo Orchard, which is to the west of the conservation area, and that would form a historically coherent picture of how the conservation area, how the area has maintained its significance over the years. And the third boundary change is at the very top end, colored in blue, which is to include 2 properties which are early 20th century properties, and they do form a good historic significance aspect of the conservation area. So the recommendation is to include these 3 boundary changes in the current conservation area boundary. And the document attached as Appendix 2, it reflects the changes as per the responses received during public consultation. And our recommendation is to support and agree the changes proposed in the review document.
Are there any comments or questions? Councillor Palmer.
No, apart from to say I walked around with Jamil, and I think the parish council was very impressed, and I think it's well supported locally and by the parish council, and I think it's a very good report and we should progress it forward. Thank you, Chair.
I have just one question about the inclusion of the cuckoo orchard. Will that have an effect on the trees in that area? Because those look traditional, semi-traditional type of orchard. Would that mean that that pattern of farming would be preserved as part of the conservation area, or is there the risk of it being grubbed out and put down to more intense types of farming in that area?
Conservation area designation does not specify whether it's going to be active farming or passive farming, but what it does provide protection is in terms of maintaining the orchard and the nature of that area, along with its build structures, and perhaps along with its more mature and significant trees. Now, when it comes to, say, for example, if it was a working orchard, there would be certain amount of felling and coppicing and things required for the tree. And that would be part of the process of maintaining that area as an orchard. So in terms of if we were to, I don't think as conservation area designation, sorry, let me rephrase it. Conservation area designation would in a way ensure that that area of orchard is maintained, and there would be a lot more resistance towards any intensive development in that area.
Would that include perhaps the polytunnels, if that was in that area? Would that be something that would be, or does that come under permitted development? We need to refer to the planners here. There's blank looks here, but no, anyway. Yeah. Okay, so the recommendation is that we asked Policy and Resources to progress this. If all those in favour? Yep. Thank you. Thank you very much, Jamil. There's some excellent work.
Thank you.
And I think that brings us to the end of the meeting. So
Thank you.
I've been told that polytunnels are permitted development. So that's the end of the meeting at 8:44. Thank you very much indeed.